Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine. Here with me is my co-host, Alan Reineck, executive director of the Church State Council, and together we're trying to recover religious liberty from the political extremes. So welcome today, Alan. It's good to be back on the program with you.
It's wonderful to do another segment, and very excited about our guest today, a good friend and colleague, Hiram Sasser from First Liberty Institute.
So speaking of Hiram Sasser, Alan, as I was researching for this interview, I came across a news story about another case that Hiram is involved with called involving a fire chief in California, Chief Hiddle. And as I was reading through that news article, I had confirmed something that I have long suspected about you, which is you pop up everywhere because there your name was in the middle of this news story.
Oh yeah, Ron Hiddle's been my client for quite some time.
So, since this is really what we're talking about in this program, tell us about Chief Hiddle.
Ron Hiddle is just a fantastic Christian gentleman. When he got fired he worked his way up through the ranks. He was union president for a time. Then, which because of his leadership skills, went on to become fire chief for a very tough city. Stockton is a tough place to be in leadership. And they brought in a new city manager to ostensibly take them into bankruptcy, and he immediately took a dislike to Hiddle, who introduced himself as a Christian, and that immediately set him off. But he has since gone on to be a principal of a large Christian academy and serving the Christian community with his leadership skills, and just I have been blessed by his witness to me and to meet many of the firefighters in the city of Stockton who gave deposition testimony. It's just been a marvelous experience representing him.
I hope we will get to discuss this case in a little more depth in the interview that we do in a few minutes, but it really does introduce this broader topic of whether you're a Muslim, a Hindu, a Christian, whatever your faith tradition, how much of that faith should you bring to the workplace? I mean, what is appropriate legally to do that? And that, to me, seems to be sort of this gray area. People aren't really sure how they should express their faith in their place of employment. I mean, this is your bread and butter, Alan. I mean,
look, one of the things I asked Chief Hiddle when we first were getting into this is whether he was proselytizing in the workplace, whether, he would pray with folks in the workplace. No, he lived his faith in how he dealt with people, in his leadership style. He implemented, his Christian values, but he was not wearing his religion on his sleeve. And, there's plenty of kind of cases involving the sort of blending of religious freedom and free speech, and especially in the government workplace. But that's really important because obviously there are boundaries here. And no, the workplace is not a place to be proselytizing and imposing your religion in ways that make other people uncomfortable. But, at the same token, nobody wants to be proselytized for somebody else's values, religious or otherwise.
Right.
So it kind of cuts both ways.
Yeah, there's a balance there. So why don't we pick up these issues in our conversation with our guest today, Hiram Sasser from the First Liberty Institute.
In our series about why liberty matters, we're turning next to why liberty matters in the workplace. And the religious freedom community is kind of a close-knit bunch, and so I've invited friend and colleague Hiram Sasser, Executive General Counsel for First Liberty Institute, and in the interest of full disclosure, First Liberty, with Hiram's brilliant leadership, really secured a 9-0 Supreme Court win for one of my clients, a mail carrier from Pennsylvania by the name of Gerald Groff. So, Hiram, welcome.
Hey, well, thanks for having me.
And we're going to talk about Groff's case and others concerning workplace. Is religious freedom in the workplace, in your view, one of the really critical religious freedom issues in our country?
Well, certainly it is. I think that a lot of people sometimes misunderstand religion in the workplace. They sort of make demands on people to sort of kind of cubbyhole their lives and put their lives in little boxes, and so you can have a faith, but your faith has to go in the faith box, and the faith box only gets opened on at your place of worship, maybe on some special holidays, but otherwise that's the faith box. And that's just not really how people of faith live out their lives. I mean, from not just Christians, but any faith, the Jewish faith, the Islamic faith, any faith that you would name is part of somebody's life. It's part of who they are, and especially in the United States, people spend more and more time at work than they do almost in any other endeavor. And so the idea that we're going to demand people of faith to keep their faith hidden and closeted away and has to be in the little faith box, not to be opened at all at work, that doesn't seem to make any sense, and that doesn't seem very realistic. And so, I think we have to, start from that position, is that you're not going to be able to have a faithless work environment where everybody takes off whatever religious garb they may wear, their faith may require them to wear. We're not going to have any cross necklaces, no hijabs, no yarmulkes, nothing of those natures. And we're not, no one's celebrating any religious holidays by having certain days off or whatever. Like, that doesn't seem to me that that's a solution and that's going to work. And so if zero is not going to work, then something more than zero is what the answer is. And really the question then becomes, how much more than zero should religion be accommodated at work in a way that makes sense for the work environment and for the people of faith in general?
So, Hiram, Alan referenced a case right at the beginning, Groff versus Dejoy. Can you give us a sense of what a person of faith could expect in the workplace before Groff and what they could expect in the workplace after Groff, in terms of how they can express their religious selves in their place of employment?
Well, sure. Well, so, Congress really took the helm here, and legislatively decades ago said, look, we're going to require employers of a certain size, not small businesses, but more than 15 employees. We're going to require them to accommodate people of faith, accommodate religious practices or activities while at work, or make space for them in some way, make certain accommodations. We're going to require them to do that. And so the question became, well, how much do you have to allow before you say, well, gosh, we can't allow certain things because it's going to have some sort of negative impact on the business? And so Congress, through debate, through our elected representatives, we the people, sort of hashed out a deal. We cut a deal with each other. And the deal was that you had to accommodate somebody's religious request based upon their sincerely held religious belief, unless doing so would cause an undue hardship. And that was the language that was chosen by the people and the people's representatives through a negotiation. That's how a Republican form of government works. We negotiate and we cut a deal. But what happened was the Supreme Court decided that undue hardship, they didn't like the deal. they decided that the deal wasn't good enough for businesses who last I checked, I mean, they're not short on lobbyists in Congress. Like, it's not like the members of Congress didn't hear from the businesses. But apparently the Supreme Court justices were concerned that the businesses didn't have a big enough voice and that the little people had too much voice, I guess, in Congress. I don't know how that would work, but that must be the vision that they had, because they decided to water it down and say anything more than de minimis as an impact on the business is enough to say we're not going to accommodate your religion. So we went from undue hardship to anything more than de minimis, which was essentially nothing. And so what the Groff decision did was get rid of that de minimis watering down and really reinstituted undue hardship. They threw in some extra words in the decision, substantial burden, but it's just that's synonymous with undue hardship. So elevated the standard. So whereas before, if somebody wanted to have they had a particular day of the week that their religion required them not to work on, and they asked for an accommodation, before under the de minimis standard, well, if it had any small impact at all, it was kind of inconvenient to do that. An employer could really get away with saying we're not going to make that accommodation. Whereas now the employer actually has a burden, a real burden. They have to show up with evidence and demonstrate that that this is going to be a real undue hardship. This is going to be an actual real problem. And I think that the burden was always on the employer, but now the amount of evidence that they have the burden to produce and then to then persuade the judge of the using the higher standard of undue hardship or substantial burden, if you want to use the language from Groff, that's given a significant leg up. And so that person who would have been denied their religious accommodation for their day off of work for religious reasons stands a much better chance of winning, because now the employer has to show up with this truckload of evidence that before was not required. And so that's really not only changed the dynamic of what would happen at the courthouse, but I think changes the dynamic of what the discussion will be with HR long before there's any kind of litigation.
So, Hiram, most of the cases involve these conflicts over accommodations, scheduling accommodations like Sabbath observance. Groff, his deal was the Lord's Day, and he would not deliver Amazon packages on Sundays. There's cases involving dress issues, beards, head coverings, etc. But then there's another whole class of cases that are just outright religious discrimination. They're not accommodation cases. And I think in particular of the other case that you and I are involved in together, representing a fire chief who was fired from the city of Stockton, California, really because of his, it was religious discrimination. He attended a leadership conference put on by Willow Creek, a brilliant, fantastic leadership conference. They didn't care how good the training was. They just saw him going to a religious event, and that was enough for them. How are the courts? Are the courts receptive to these religious discrimination claims that are not accommodation cases, that don't involve these kinds of disputes over scheduling or dress or appearance issues?
Yeah, I mean, you're going to have in any kind of employment situation, you're going to find situations where people decide they don't like somebody for certain reasons, and they start mistreating them, or maybe the employer takes adverse employment action against them, fires them, demotes them, transfers them, those sorts of things, because they don't like that person, or they don't like their religious practice or their religious beliefs or what they do. What happened with Chief Hiddle was they didn't like the fact that the training that he went to and that he took some folks to, was put on by a church, even though one of the presenters there was Sheryl Sandberg, or has been a presenter in the past, the former, chief operations officer for Facebook. And I mean, I'm sure, from all accounts, I've never met her in person. One of my colleagues here has worked with her in the past, but I think that she's probably a really nice person. I don't know what her faith position is, or what faith she has, or she has any faith at all. But I wouldn't classify her as an overly religious person. But yet she was participating in this conference because it was a conference, a leadership conference, really addressed at a lot of different people, including people of faith, but people in those types of leadership positions in general. What's fascinating about that case is that the city said, no, look, we don't like it because it's religious, and it was hosted by a religious person. So it was just their overt hostility. And you would think that there'd be that's enough direct evidence, them saying we don't like it. And their independent investigator that they hired saying, all this religious stuff is really, really bad. And that's why we have to take action against Chief Hiddle. You'd think that would be enough, but for whatever reason, that has not been enough so far in that case. And I say so far because, we have other layers of court to go to. But, one of the things that's been really difficult in a lot of cases is that, whenever you suffer religious discrimination, overt discrimination in the workplace, we've had some cases like that here at First Liberty where the employer is really good at hiding it. And you have to try to figure out, well, how are they treating the non-religious employees versus the religious employees, and try to see what how is the treatment different, and having to provide, dig up evidence to substantiate that. The evidence battle on those discrimination cases is really where the rubber meets the road. They're very difficult cases to bring against employers because it doesn't take a lot of know-how to hide your discrimination relatively well. What's fascinating about the Chief Hiddle case is their discriminations is all over their independent report. And yet, even in that case, we had a panel of 3 judges who ignored all that evidence. That was evidence supplied by the employer, not by Chief Hiddle. And so, I guess we'll have to find out, well, how much admissions against interest is it going to take for the Chief Hiddle to be able to demonstrate enough evidence of religious discrimination? But those cases are just very, very difficult,
right?
Because they involve evidentiary battles, and
I asked the question
for the employees to get that evidence.
I asked the question because, we've had a pretty good track record on accommodation cases, even with the lower standard, but the flat out discrimination cases we've pursued have been a much harder battle, and we've been much less successful.
So, Alan and Hiram, I mean, this is a great opportunity with 2 attorneys who work in this space. If someone is listening and they're experiencing what they believe is overt religious discrimination in their workplace, what are the next steps? What would you advise them to do?
Document. You have to document every instance that you believe that you're suffering from religious discrimination. You have to document every time you see someone who does not share your faith and how they're treated in similar circumstances. And you really have to almost kind of suffer under religious discrimination for quite some time as you go about your documenting and printing of emails and building your file until finally you have your mountain of evidence to go see HR. I have a phrase for this actually, and it's called phone book 'em, which is that you need to have a stack of evidence that's relatively the same in thickness as an old phone book. This is kind of dating me a little bit because I guess they don't print them anymore, but like an old printed phone book. That thing used to be about that thick, right? You need a big, thick file of recorded discrimination before you go see the HR department to then complain about the discrimination. Without that, you're going to face an uphill battle.
I'm shaking my head, Hiram, because I've never had a client come to me with all of that. Now, in some jurisdictions, it is legal to record without the other person's knowledge, phone calls and such. And I've done very well in those cases when we have recordings. California, you need consent, and people should know what the laws are in the state that they live in. But yeah, documenting, putting the employer on notice, utilizing internal complaint procedures. And keep in mind that for most of the country, if you are going to bring a complaint formally, legally, you're going to have a very narrow time frame with the Federal Civil Rights Agency. Some states it's going to be 240 days, and others it's going to be 300 days. So you need to keep, but that's, the clock starts ticking there from when there is like a demotion, a suspension, a termination, some kind of concrete act. We call them adverse actions.
That's why you got to record and document all the actions leading up to that as well. And it's also a great idea to consult with an attorney at the very first, beginning of the process where you think you might be suffering from religious discrimination at the workplace, because the lawyer can help walk you through all the processes internally, all the documentation that you should do. I mean, I've actually had a case where I got a call really early, and we were able to walk the employee through a lot of process. And that file was pretty thick before the employer made the mistake of terminating them. And then once the employer made the mistake of terminating them, we had a really great case, which ultimately we prevailed on at the federal courthouse. This was in Texas.
Gerald Groff came to us at the beginning, and we were able to work with him through the very exhausting federal process. We get calls for accommodations before people get disciplined or terminated, and we've had some success at helping people get their accommodations. But I do need to give a caveat here, because this is not an advertisement to contact either one of our organizations, because after the Groff experience, I think we're pretty buried. But
but what I mean is, you need legal help. It's good to get a lawyer involved early, and there's plenty of groups that handle religious liberty cases on a pro bono basis. There are other law firms that do it on a contingency fee basis, and good lawyers who do this kind of work want to be in on it early.
Right. And I should mention also that Liberty Magazine, the magazine I edit, if you go to that website, libertymagazine.org, there is actually a phone number that you can call, a hotline, if you're experiencing or believe you're experiencing religious freedom violations. And we'd be happy to direct you to someone who could assist you. And, this has been such a fascinating discussion and very practical. But, I would be curious to know, Hiram, what exactly drives you in this work? I mean, this is such a specialized area of expertise that you've developed over the years. What fuels your work in this area personally?
Well, I feel called to do this work. I mean, this is, everybody has something that I think they're called to do. I felt that, when I became a believer in adulthood, while in law school, as a matter of fact, what do I bring to the table? Well, I'm rather cantankerous, and I like to cause trouble. and so, I'm although I do serve in children's ministry at my church, I'm probably not the person that you're going to go send to go, to console someone in their hour of need. But when they are in real trouble, I like to be the person that I feel called by God to be the person that says break glass in case of emergency, and I really enjoy helping people and resolve and solve emergencies. There's nothing more exciting to me than someone coming in the office when I have a slate of work to do and someone saying, "Hey, listen, I have an emergency," and that's why I got up that morning. I was hoping to have an emergency. So that I just feel called to do this. And the other thing too is that a lot of times people of faith have a hard time with confrontation. Because let's face it, especially Christians, Jesus said, don't let their, to turn the other cheek and carry the rucksack the extra mile. Somebody asked you to, all those sorts of things, and it rightfully so puts people in it. They don't want to go around looking for trouble, and we're not called to do that. But Jesus also did not back down from battles with those in authority, civil battles, battles of words. And we are fully capable of doing that, of going into the marketplace like Paul and standing up. And even if that incites a mob, I guess, right, in Ephesus. But we're called. I just feel called to use my penchant for dealing with emergencies and my not shy about confrontation to be able to help people of faith.
I love
Well, Hiram, let's leave it there. You and I, are kindred spirits. I went to law school because of my sense of calling to religious liberty work. And just really appreciate your being with us today.
Thanks.
Well, thanks for having me.
Well, that was one of the more practical interviews we've done so far, right, Alan?
It was. And, it prompts me, Bettina, to kind of sum up and address kind of an issue that he only sort of leaned into, which is how Christians decide to go ahead and pursue these discrimination claims,
right,
in light of the kind of turn the other cheek. And I've met Christians who absolutely will not bring personal injury cases and think they should never have anything to do with the courts. And I wonder if I could just share a take on turn the other cheek that I learned years ago. The natural human response to conflict, we're told, is what? Fight or flight, right? Mm-hmm. So if somebody is, hitting me on the cheek, then either I'm going to slug them back and retaliate in force, or I'm going to run away. But if I turn the other cheek, I'm not doing either one, am I? I'm not retaliating. I'm not escalating the conflict, but I'm not running away from it either. But I am calling the wrongdoer to account for his wrongdoing. And I think that's what, Jesus does not call us to run away from conflict. And I will tell you that almost to a person, my clients all say they don't want this to happen to somebody else. That's why, they want to hold the employer accountable. And they know that, whatever money there is in a case, that's not changing anybody's life, right? So, these religion cases, these are not like your multi-million-dollar personal injury cases.
No,
nobody's laughing all the way to the bank on these cases.
And, Hiram referenced the early Christian church, and the early Christian church was by nature countercultural. They stood in contrast to, the norms around them, and whether they liked it or not, they had stuck their head above the parapet and they were going to get knocked down. But they still chose to raise their head and to be visible emblems of that sort of countercultural value system that Christianity gave them. So, yeah, it's a difficult calibration to make, right?
Well, he started the interview by pointing out that, we just can't put our faith in a little box and
Right.
reserve it for,
Yep.
church service, for Sunday or for Sabbath, right? It's part of who we are. And
Right.
the notion that you leave your faith at the door when you come to work, well, I'm going to leave then I'm leaving myself at the door when I come to work. It just, you can't separate it that way. So
No.
I thought it was a fantastic interview.
Yeah, absolutely. Well, Alan, it's been another great show, and thank you everyone for joining us, and we hope you'll come again. This has been Just Liberty, where liberty and justice meet. I'm Bettina Krause here with Alan Reineck, and until next week, remember, eternal vigilance is the price of liberty.